Well, let's go to New York now and speak with Douglas Burns, a former federal prosecutor. And Douglas, we guess you're hearing that the defense is about to begin its closing arguments. They presented, as we heard, no witnesses, presented no evidence. Does Manafort have any chance here? And what was the strategy?
Well, it's very common, actually, to see no defense case, but it's still a very big catch-22, because what happens is you can have all the rhetoric you want about, they're telegraphing that the government didn't prove the case. That's really not what's going on. What's going on is the defense is making a calculation that they don't want to make it worse, ironically, seriously, and particularly putting the defendant on the stand, which I knew would never happen. So the point is, they're going to argue along conventional, fundamental, white-collar lines. The government's summation had a chance to look at some reports about it. Did not surprise me at all. They emphasized that documents are much more important than testimony from somebody like Gates. That's not surprising in a white-collar case. The witness says, we opened a bank account. There's the sheet showing the bank account, and document after document, argued that they met their burden of proof. Globally, they argued that A, Manafort made a lot of money lobbying with Ukraine, B, didn't pay taxes on it, C, hid a lot of it, and then D, when his income fell way down, he turned around and was untruthful on bank loan documents. So a lot of it is supported by documents. The defense, which, as you just said, is starting literally right now as we speak, they're going to be saying that, the cooperator cannot be trusted. He lied. He was convicted of lying. And then there's one thing in there, guys, seriously, that's pretty helpful to the defense, and that is that the defense is usually knowledge. Our client, the defendant, Paul Manafort, didn't know of certain things. And the point is, the cooperator, Gates, apparently embezzled money from Manafort without his knowledge. And trust me when I tell you, they're going to argue that a number of times this afternoon.
Well, Doug, if they failed to use that argument, given what seems to be a lot of very clear proof and meeting the burden of proof, as you say, one of the options that's thrown out into the air is that word we keep hearing, pardon. Is that really on the table? How would that look?
Well, that's wildly speculative, but I'll put a couple of points on that pencil. I mean, not only is there a pardon power, by the way, but there's a power to commute a sentence without granting a pardon, and that came up in the Bush administration with, I believe it was Scooter Libby. Okay, so the point is, people are getting a little too quick out of the gate with talking about pardons, but maybe, just maybe, depending on how it all plays out, and I certainly don't want to speculate, I never do, while a trial is, underway. But the point is, there could well down the road possibly be some discussion about commuting a criminal sentence. But again, that's getting a little bit ahead of it. But it's a fair question, certainly, that people have been raising.
Doug, let me just ask you, there's another possibility, and Paul Manafort has said he is not going to flip on the president. But, of course, we have to see this verdict here. He's got another trial coming up. How common is it for a defendant to wait until he gets that guilty verdict and then turn around to the prosecutors and say, okay, now I'll make a deal with you?
I'm glad you asked me that, because my answer is going to surprise you and probably a lot of other people. And that is that in the day-to-day real world, even though I don't love that term, but in the day-to-day practice of federal criminal law, it's extremely, extremely uncommon for prosecutors to entertain cooperation after they've been forced, for lack of a better way to put it, to prepare for and go through a full-blown trial, okay? Having said that, however, this case shows us the mix between, political factors and criminal law factors. So here, to answer your question, if Manafort were hypothetically to offer up cooperation after a hypothetical guilty verdict, I think the government would sit down with him. But in the day-to-day practice in my 33 years, very, very uncommon. But here you'd see it because of the political toxicity and the political context of this case.
And not altogether a very common situation overall. Doug, before we wrap, just in the little time we have left, barely any mention of Manafort's work for President Trump, for the Trump campaign during this trial. No talk about potential allegations of collusion. Do you think there's any impact here for Mueller's probe going further?
No, it's a very good question, and a lot of people have been positing that. I've said once, I say it again, you have to look at this trial two ways. One is in isolation, and then two is in context. Isolation we've already covered, and that is you have the bank fraud, the tax charges. But in context, you're exactly right. I mean, well, wait a minute, how does this square in with the Mueller probe? Again, politically, you've heard those from the hard right saying this has nothing to do with the Trump campaign and so on and so forth. But at the same time, depending upon the outcome of the case, it may have some type of impact on where the Mueller probe heads, but it's hard to say.